Good morning, Commissioners O'Brien and Ashby, and Commissioner David is here. Commissioner Douglas is here as well. And I think we're just waiting for Commissioner Walker, so we'll get time. Good morning, Commissioners O'Brien and Ashby, and Commissioner David is here. Commissioner Douglas, that's on your computer. I think we're just waiting for Commissioner. So we'll get time. Meeting, the live stream on here.
I did.
Yes, that I remember. Do a lot of mediation,
Oh, really?
foreclosure mediation.
Sure, yeah. I stopped doing the foreclosures because
Yeah,
there was so much demand for the families, so I just
right.
stayed with that.
So maybe that will help. They can you still hear us in the meeting? Julie, can you hear us? All right, good. Commissioner Walker, I'm gonna bother you about this too. I need you to fill out a vendor form.
I know.
I already attacked Tom Douglas. He will fill it out before you leave today.
All right, I will try.
No one leave until you fill one out. If you need legal
I just yelled
representation.
at him about that.
Feel better now?
You should feel better. It's
Okay.
not personal.
We're all being yelled at.
The,
Yeah, I was up.
the state network of public access, that's what I'm looking for.
Yes. Yes,
Public access.
yes,
is
the
Wi-Fi.
public access.
Yeah,
Yeah,
we're using a hotspot, so it's public access should be fine.
it should be fine.
Well, there, one thing will make her happy.
No. No, let's not,
You won't get yelled
let's
at.
not play that game.
You know me, just teeing them up for you.
Nothing terribly positive is gonna happen today.
Okay.
Except this.
So it connects, but it's no internet, but.
That is not uncommon. It should kick in.
Should kick in, we'll find it sometime. We hope.
Chelsea, just, you know, I had you pinned on there, the commission meeting one, just while we were waiting. So you don't have to stay pinned there. You can. Commissioners, I sent you, I'll wait till work session.
Does have to stay pinned. Isn't that going to turn into being us? For people who are streaming, that's the room, right?
That is the room, you're right, she does have to stay pinned. Yeah, okay. You guys are figuring it out. Oh, right. So, yep. I'm gonna unpause the recording. In case anyone needs the first thing that I emailed you. That would
Right, the right to sue?
Yeah.
No, I've got that, I got it. I do not have all the consent.
Those are, you had a link.
Yeah, I know.
Yep.
Yeah.
Amy, you can hear me okay?
This is again that you're just
Million.
Amy, can you hear me okay?
That's what's happening here.
In the tin there, Julie, I'm sorry you're not here. I decided everyone had such a good time with the snacks you brought last time that I filled your tin up with some non-homemade chocolate, dark chocolate covered raisins. So they're there for snack. If anybody wants them.
Thanks.
Yeah.
Yeah.
You didn't have breakfast. That's not quite breakfast, but it's not nothing. Oh, you got there. You got donuts? We should be at your. We should go to Julie. Yeah.
Really needs to be in person.
He is not feeling 100%. But she's here, which is very impressive. If you're talking to us, we can't hear you though.
I'm here for now.
We cannot hear you, Commissioner Ashby.
Can't hear any of them.
I'll try again.
So
Can you-
Chelsea, I have now messed with all the controls in your computer. So I don't know what's happening there.
You cannot
Good
hear me?
luck figuring that out. We're working on it here.
All right.
And when I
Julie,
say
can you
we, I
hear me?
mean-
Can you hear me?
And you can hear us both. Okay.
Royal we.
The royal we.
Steph and Julie, I can hear you. Can you hear me?
That's how we like to.
Okay.
And Julie, I can't.
Can you hear me now?
I can hear you. Can you hear me?
Yes. Is this
Okay.
Kit? Is this
Yeah,
Kit?
that's Kit.
Yeah, yeah.
Interesting.
Good work. By Chelsea. Yes, it could be done sooner. Yeah. Depends on how many rooms I said. No, pleasantries. Didn't have the open, you plan to.
I'm having a challenging time hearing you. Can you hear me okay?
Yeah. Yes, I can hear you.
Okay.
Kelsey has just activated some sort of loudness device here, some sort of robotic device.
I heard you much better 5 minutes ago.
My computer is muted. Yes, my computer is muted because if I turn my microphone on, then I get feedback. Room microphone. Yeah.
Amy, can you hear me?
Very faintly.
Okay.
So I don't know why, the sound is much less. Your sound instead of. Okay.
Yeah.
We're working on it. Uh-oh.
Hey. Yes. It can't hurt.
Oh. Commissioner Ashby, you want to give it a try?
Yeah, that's much better. How about me? Can you hear me okay?
Yes.
Good job,
Good job,
Chelsea.
Chelsea.
Words were just reversed.
Yep.
All right.
And apparently that matters.
So Amy, I'm aware you want to discuss this right to sue issue. That's new business. Can we get through my opening remarks and
Yes.
through the meetings first or the minutes first?
Yes.
All right, good morning. I'm Jeff Ashby, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device to ensure that they are silenced now. We have additional agendas, including the consent agenda. I'm now able to say they are available, I think, in the back of the room. Is that correct, Amy?
That is correct.
Or they've been provided electronically. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on these cases and they will not be considered further today. Our first order of business today is to adopt the agenda and the consent agenda. Do I have a motion to do
Well,
so?
actually, Commissioner, I'm sorry to interrupt you. Before we have a motion to do that, I would ask that the commissioners review. We have a request for a right to sue letter
Oh,
in a case that is on our consent agenda, and if it were granted, it would change the agenda. So I would ask that the commissioners review and make a motion regarding the request for a right to sue letter in PA 210484.
Amy, I'm going to recuse myself from consideration of the motion.
Okay. Commissioner Davis,
I move that we not do a right to sue letter for the reasons stated in the motion, in the memo.
is there a second?
I'll second that.
And Tom's. Is there any discussion? Just to remind all the commissioners that because people are participating remotely, we will be following our remote participation guidelines, which means that for every single vote, I will have to poll each and every one of you, and we need to both hear and see your response. So the motion is to deny the request for a right to sue letter. If you are in agreement, you will say yes. Commissioner Ashby.
I'm going to abstain.
Okay. Commissioner David,
Yes.
Commissioner Walker.
Yes.
Oh, hold on, I forgot Commissioner O'Brien. I'm sorry, Commissioner O'Brien.
Yes.
Commissioner Walker, Commissioner Douglas.
Yes.
Thank you. Sorry, I'm all out of sorts. So yeah, with that, I'm all set, Commissioner Ashby. Thank you.
Thank you. That doesn't change our consent agenda then. So I would ask now for a motion to adopt the agenda and the consent agenda.
So moved.
Second.
So it's been moved and seconded to adopt the agenda and consent agenda. If you're in agreement, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
yes,
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes.
Since you guys were appointed at the same time, I'm just gonna like switch back and forth. I think it goes last. Commissioner Ashby, the minutes from December.
Yes. I'll entertain a motion to accept the minutes of the December 2022 commission meeting.
So moved.
Second.
So it's been moved and seconded to adopt the minutes from the December 2022 meeting. If you vote yes, you're in agreement. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
yes,
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
I forgot to ask if there was any discussion, but I sense that there was not.
All right, well then next is Amy's director's report.
Yes, thank you. So first up is the administration report. The only change since the last meeting is that we have a new investigator who is sitting right here, Nooper Leva.
I'm sorry, what's her name?
Nooper.
Cooper. Hi.
Next, we have the compliance report, status of reasonable grounds cases. Since the last meeting, there was one successful conciliation, 2 unsuccessful conciliations, and there are 6 reasonable grounds cases in which conciliation efforts are ongoing. The one successful case, you have a memo purportedly from me, but really from Jane O'Reilly, discussing the conciliation agreement in Was, I'm sure I'm pronouncing that wrong, versus Walgreens E200464. And we're asking that the commissioners vote to approve that agreement. And I'd be looking for a motion to that effect.
I move we approve the conciliation agreement for E20-0464.
second,
So it's been moved and seconded. Is there any discussion? Commissioner Ashby?
No, I was gonna vote.
Oh, okay. I love the enthusiasm. So it's been, oh, hold on. Do you see this message? They can't see Julie or Jeff? Are their videos on? Yes, their videos are on. Kit wasn't able to see Julie or Jeff. So the motion is to approve the conciliation agreement in E200464. All those, if you're in agreement, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
yes,
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes.
Thank you.
Amy, I will note that I actually can't see Julie.
You can't see Julie.
No,
Okay.
I can see Julie represented on my screen, but it appears as if her camera's not on.
Huh,
And
okay.
that goes the same for Kit, Alex, Judy
Yeah,
Shaw,
cameras.
in fact, everyone else except you in the meeting.
I agreed. That's the same with that's the same with me. I can see you, I can see the meeting, that's it.
Can I interject real quick? It's because if there's too many people on the screen or too many participants, then only some of them appear. To save bandwidth, only some appear as videos and the others just appear as their initial.
Thank you. And it says only the host can see everyone's video, and on the YouTube stream, they can't see anything except Chelsea's stream. Okay, we will thank you all for letting us know. We're going to continue working on that. On the YouTube, they should only see pretty much Chelsea's stream, I think. They should see the Zoom room. That's what they should see. But there should be pinned. We're going to keep working on it. Okay, we are still streaming. All right, let's just keep going and we're going to do the best we can. Next for investigation. We have in the month of December, we received 38 new charges. Oh, actually, I'm sorry. Let me go backwards for a minute to conciliation because there were 2 fully implemented conciliation agreements that I'd like to ask you to dismiss the cases. So again, there are 2 memos, both purport to be from me. One is about E180346, Lambert versus Town of Norwich Walk. And the other is E200150, El Barbary versus Penobscot Company. Both of those cases, the conciliation agreements are fully implemented. So I would ask that you make a motion to dismiss both of those cases.
Amy,
Yes.
I have a question.
Okay.
these cases, I never heard them. I don't believe, because it was before I was on. Am I still able to vote on that?
I believe so.
Yes.
Yes, yep,
Hey, thanks. Then I'll make a motion that we accept.
okay, thank you. Is there a second?
Second.
Thank you. So it's been moved and seconded to dismiss both of those cases of fully implemented conciliation or leave. Is there any discussion? Seeing none, if you're in agreement with dismissing both cases, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
Yes,
Commissioner Douglas,
Yes.
Commissioner O'Brien. Nope, Commissioner Walker.
Yes.
Thank you. Not had enough coffee yet, apparently. Okay, so back to investigation. In December, we had 38 new complaints filed. There were 5 cases administratively dismissed. And for predetermination settlements, there were 11 with benefits of just almost $183,000 to complainants. This is a quarterly meeting. With respect to education and outreach, I think you have a report showing that commission staff either delivered or participated in 14 events, educational events in the past quarter. Pending inventory as of now, I believe, is 717 cases. And finance, you do not have a report, but I will get you one by the end of the week. For litigation, I would ask that we take that after executive session. And then for new business, just a couple of things. One is that the legislative session has started. We will be going on Thursday every 2 years in the long cycle. So we have a 2-year cycle. The first year is for sort of all legislation. The second year is a short session for emergencies, theoretically. And every 2 years, when there's a brand new committee, and some legislators who aren't familiar with all the agencies that report to that committee go and introduce themselves and basics about them. So we're doing that on Thursday. And also there is an annual report. I think we are finally going to be caught up on annual reports. We have the FY22 annual report. So that's for the year 7/1/2021 to 6/30/2022. Finally completed. Will be by the end of the day, but Commissioner Ashby has looked at it and I will be sending it in to the state tomorrow morning. And it will be up on our website. I'm happy to give you guys copies if you want. It's full of riveting data. And that is all I have. Commissioner David?
When you say the 717 in the inventory, what is that, all statuses or?
Yes, that is every open case.
Every open case, which could mostly would be investigations, would it not? Or
Well, actually, I would say about 45% cases in the beginning part of investigations. So complaints,
right. Filings.
intakes, or early filings. Then I would say another 45% is with investigators or being reviewed for investigators reports. And then the other 10% is stuff in litigation or conciliation.
Okay. Thank you.
That's just off the top of my head guess. And that's all for new business.
That leaves us 2 minutes then, and I suggest we take a breather and I'll start back up again in 8:45.
Great. And commissioners, can you let me know if you can see each other now and sound and visual is the way it's supposed to be? So Jeff,
I am starting to see people one by one. They're coming on.
okay.
Yeah, Kit keeps flashing on and off. There they are again.
Probably doing that on purpose.
They're just
I'm good. This is working either way. No offense to Kit or Julie, but I don't have to see them, I guess.
You're
I
absolutely
think it's just for the votes. It's important that we can actually see you.
See our hands. Yeah.
thank you.
Fair enough.
Glad everyone is visible. All right. The YouTube stream is showing what it's supposed to be showing.
Mayor, have you been saving that your post? Ridiculous question.
No, it's about this morning. Aha,
Hey, look at that.
wow, it's just about to try to figure out.
Oh.
You're exactly on time.
Morning.
All right, the remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that the commissioners may ask questions. I will ask that you introduce yourself as you come to the podium or appear electronically. The first case today on the agenda is E20-0540. Michael, forgive me if I mispronounce your last name, Figuera versus the York School Department. And this is at least there's one reasonable grounds finding in this case. And so I believe we're going to hear first from the respondent.
Correct, and I would just remind folks not to use the names of any third parties. We've given them pseudonyms or other ways to refer to them in our report.
You want me to come up here?
Yes, yep, and you can take your mask off when you're presenting.
Okay, great. All right, good morning. Can everybody hear me okay? Awesome. All right, good morning, Commissioners, Executive Director, and Commission staff. Thank you for having us. I'm Kathleen Wade. I'm an attorney from Drummond Woodsum, and I represent the York School Department. We're here to register our disagreement with the investigator's reasonable grounds finding on sexual orientation discrimination, and also our agreement on the investigator's decision that there are no reasonable grounds to believe that disability discrimination or retaliation occurred in this matter. I know that you have read the investigator's report, so just briefly, I will cover the background, which is that the complainant in this case was a case manager, which means she was tasked with working with teachers, special education staff, educational technicians, and others to essentially organize and implement the programming of students who are on her special education caseload. On May 29th of 2020, she filed a complaint with the York School Department alleging that her supervisor had made a series of disrespectful comments regarding her sexual orientation. The York School Department immediately initiated an investigation into that allegation by the assistant superintendent, who did determine that there were unprofessional comments that had been made regarding sexual orientation. That was promptly followed by discipline to the supervisor, as well as training, which was specifically organized by the York School Department following this incident to make sure that all supervisors were aware of their obligations with respect to discrimination, harassment, retaliation, etc. After that discipline and training took place, there were no additional comments regarding complainant's sexual orientation ever made to her by supervisor or, as far as we know, anyone else. This is where we register our disagreement with the investigator's findings and report. So as a legal matter, we agree that there are 6 elements to a hostile work environment and claim, which are outlined in the investigator's report, as well as your school department's disagreement with that report. And there are 2 that we do not believe that the complainant has met the legal burden to demonstrate as necessary to essentially find reasonable grounds in this case. The first is number 4, that the harassment was sufficiently severe or pervasive so as to alter the condition of complainant's employment and create an abusive working environment. The findings here were a bit conclusory and determined that they were severe or pervasive. York School Department disagrees and is not sure that severe or pervasive alone is enough. It has to sufficiently alter the conditions of the working environment, which has never really been alleged in this case. In addition, and more importantly, we do not believe there's been an establishment that the York School Department has employer liability here, which is element number 6. And specifically, this relates to the fact that the investigator found that after the complaint did essentially what she was supposed to do, which is to report that these comments were being made, there was essentially nothing the investigator found that the school could have done to eliminate their employer liability. And that as a legal matter cannot be and is not true. Instead, in 1986, the US Supreme Court held that in Meritor Savings Bank versus Vinson, that a lower court had erred in concluding that employers are always automatically liable for the bad acts of their supervisors. That was expanded upon in the First Circuit in a case out of Puerto Rico in 1988, where the First Circuit determined that in order to determine that there is supervisor liability, you have to determine not only that an official representing the organization knew of the harassment, but that the official cannot otherwise show that they took appropriate steps to halt the harassment or discriminatory behavior. In this case, again, there is absolutely no allegation that once the school department was aware and investigated the complaints of sexual harassment and sexual orientation discrimination, that there were any ongoing complaints. No comments took place after the assistant superintendent got involved. And at that point, employer liability must be cut off. So we would urge the commission to adopt no reasonable grounds finding on that particular question. Just briefly on the retaliation piece, because I know it's going to come up today, unless you prefer I wait. It cannot be the case that an employee is insulated from discipline or termination simply because they filed a Maine Human Rights Commission case or because they've alleged discriminatory acts, right? Here, there were 3 significant incidents of unprofessional behavior that led the York School Department to reasonably determine that the complainant was unable to work with her colleagues in a collegial manner, which was disruptive to the education of students, essentially. She failed to take responsibility for those actions rather than acknowledging that she had committed a wrongdoing. And as a result, the York School Department made the decision not to offer her continued employment after her probationary year expired. We do not believe that this shows any discriminatory or retaliatory motive. And there's no evidence that there was any discriminatory or retaliatory motive. It was based solely on the unprofessional behavior and failure to work with others. As a result, we would urge the commissioners to adopt the investigators' no reasonable grounds finding on both the disability discrimination and the retaliation claim. And I'm happy to answer any questions.
Thank you. Any commissioner questions? Wait. No. Yep.
What is the significance of any of the difference between probationary period and, I mean, you're using the word, everybody's using the word that she's terminated. She's terminated from an existing contract, or they're failing to offer her a contract, and is it legally significant to your argument? So
with teachers in this state, right, there's an assumption that they get 2 years of probationary employment. Now it used to be 3 before they're offering a continuing teaching contract. And essentially each year following a probationary contract, they are either nominated or not nominated. Her employment was not terminated mid-year for the disciplinary actions. And instead, they basically use those probationary years to evaluate whether or not this is somebody who has the fundamentals to continue on to the point of essentially receiving an ongoing contract that is frankly very difficult to terminate. So basically the significance here is that York was using those years to evaluate the performance, saw some pretty significant red flags with respect to inability to work with colleagues, and chose to exercise its discretion at that point not to bring her on for a continuing contract, but it did not terminate her employment mid-year. So ultimately, she did not continue on with York following her probationary teaching years, but wasn't terminated mid-year.
You're saying mid-year?
Yes, so she completed 3 full years of employment with York, 3 full school years.
But you just said it was 2 years of probation.
The law has changed. So when she was doing her probationary
It was
years,
30.
it was 30, correct? Yes. Sorry for the confusion.
So I'm still not clear whether the fact that they failed to offer her a contract in accordance with that procedure is legally significant to the standard of whether or not there's unlawful discrimination.
I would say for your purposes, it probably would qualify as an adverse employment action that they decided not to offer her continued employment. They had no obligation to do so, but many teachers after the probationary year are offered continued employment, absent obviously significant concerns.
Is it necessary for the school district to take a positive action to not offer the continuing contract?
They have to give notice, which they did in this case. They simply have to give notice that they're not going to put her on the list to nominate her further, which they did in this case.
Any additional commissioner questions for Attorney Wade?
Awesome.
You'll have about 4.5 minutes left.
Great. Thank you so much.
And we're going to hear from a representative of the complainant.
Yes. Who is also here in green.
Good morning, commissioners. My name is Braden Beard. I'm here today on behalf of the complainant, Michelle Figuera. The investigator's report in this matter correctly found that Ms. Figuera's supervisor made severe and pervasive comments about Ms. Figuera's sexual orientation that created a hostile work environment. The commission should adopt that finding and find that there are reasonable grounds to believe that York school departments discriminated against Ms. Figuera because of her sexual orientation or gender identity. Commission should not adopt the report's second finding, which was that York did not retaliate against Ms. Figuera for reporting and opposing discrimination against her. As I'll explain, that there's ample reason to conclude that there are reasonable grounds, or at least an even chance, to believe that York illegally retaliated against Ms. Figuera when it disciplined and later terminated her. First, I'll spend most of my time on the hostile work environment claim. As explained in detail in Ms. Figuera's filings in this matter, her supervisor subjected her to repeated offensive and humiliating treatment because she's gay. This included when Ms. Figuera first told her supervisor that she was gay and was married to a woman, after Ms. Figuera had been very private about her sexual orientation in her personal life before that. Her supervisor responded, "Duh, you didn't think I knew that?" At another point, the supervisor abruptly asked Ms. Figuera if she and her wife had specific roles in their relationship, as in, is someone the traditional man in the relationship? The supervisor repeatedly asked Ms. Figuera if she knew whether other teachers were gay. She asked Ms. Figuera if she could detect other gay people because they give off a certain aura, like she had gaydar. The supervisor also repeatedly said she was excited for Ms. Figuera to meet another teacher who was also gay and that she thought they would have a lot in common. And the supervisor said the school was like a gay university because there are so many gay and lesbian staff members. The supervisor also assigned certain students to Ms. Figuera specifically because Ms. Figuera was gay. She assigned a student with gay parents to Ms. Figuera because the parents were gay and the supervisor thought they would have a better rapport. The supervisor then asked Ms. Figuera if she had clothing with a pride flag that she could wear when she met them. And the supervisor assigned Ms. Figuera a student who identifies as transgender because Ms. Figuera is gay. Further contributing to this hostile work environment, the supervisor made multiple comments demonstrating the likelihood that she would retaliate against Ms. Figuera if she reported the discrimination. She said, and pardon the language, anyone who fucked with her would get fucked over twice. The supervisor also bragged openly that she made a fake Facebook account using a name that was made to sound like "you will go down." and she used it to send intimidating messages to a woman in town that she didn't like. Many of these comments were admitted by the supervisor. The investigator in this matter correctly found that this repeated discriminatory conduct created a hostile work environment. When objecting to this finding, York School Department makes a number of legally incorrect arguments. First, York incorrectly paints their objection as related to a legal question, when in fact they're arguing a factual question. The courts have explained that pervasiveness and severity are questions of fact, and they're really only subject to some policing at the outer bounds. Otherwise, it's for the fact finder to determine whether comments amount to severe and pervasive. This does matter here where the investigator functioned as a fact finder and determined that the supervisor's comments were severe and pervasive enough to alter Ms. Figueroa's employment and create a hostile work environment. Second, in looking at whether the harassment was sufficiently severe or pervasive so as to alter the conditions of plaintiff's employment and create an abusive work environment, York focuses on whether this issue of whether any of the conditions of her employment were altered. But courts don't splice this single element out like this. They analyze as a whole the frequency of discriminatory conduct, its severity, whether it's threatening or humiliating, whether it was a single offensive utterance or multiple offensive statements, whether it unreasonably interferes with an employee's work performance, whether the conduct affected the employee psychologically. It's not a mathematically precise test, courts say. The point is really whether the harassment was bad enough to really affect the employee. And as Ms. Figueroa explained in her filings, her employment conditions were altered in that the harassment made her feel marginalized, intimidated, and demeaned because of her status as a woman. She specifically told her supervisor that she felt embarrassed and humiliated by the treatment from her. And it was bad enough that she went and talked to the LGBTQ coordinator at her school about it to figure out what she should do. And the coordinator appeared to be appalled by this. Just a quick note at York on timing, York sort of misleadingly focuses on the fact that some time passed between when Ms. Figueroa first reported the harassment to the LGBTQ coordinator, which was on March 13th, 2020, and when she filed her complaint with the assistant superintendent, which was in May 2020. But this was because the COVID pandemic, caused everything to go remote, caused an immense amount of upheaval and disruption, and that hit, sort of right after March 13th, when Ms. Figueroa first raised this. Third, as York just argued, it argues that it should not be held liable for the hostile work environment because it issued the supervisor a warning after Ms. Figueroa reported discrimination. But York is liable here because Ms. Figueroa tried to get York harassment and York did not prevent or correct the harassment. Under both federal and Maine law, an employer can only escape liability for a hostile work environment created by a supervisor if it can show that the employer exercised reasonable care to prevent and correct promptly any harassing behavior, and that the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer. That standard that is cited by York from the mid-'80s predates this doctrine that I just went over. This is the law, both in Maine and federal law. Notably, this is an affirmative defense. The employer bears the burden of proof on both elements. York did not attempt to establish the second element, nor could it because Ms. Figueroa reported the supervisor's conduct and repeatedly tried to get action taken against her because of it. York instead simply states that it took appropriate steps to halt the bad behavior. Even on that point, though, the school did next to nothing to correct the bad behavior here. It told Ms. Figueroa that no policies were violated and only gave the supervisor a warning, which it didn't tell Ms. Figueroa anything about. There was no acknowledgement from the school to Ms. Figueroa that what her supervisor said was offensive, inappropriate, and discriminatory. When Ms. Figueroa tried to follow up on her complaints, She was repeatedly told by administrators that they wouldn't revisit the issue and refused to talk to her about it. York refused to remove the supervisor from Ms. Figuera's, from supervising Ms. Figuera, and it didn't transfer Ms. Figuera to another school. It didn't try to bring Ms. Figuera and the supervisor together for any kind of restorative justice or an opportunity to really address the discrimination. York refers to training, but has not provided any detail about whether that training was specifically given because of Ms. Figuera's complaint, or whether this was a general annual training that would have taken place anyway. So because the investigator correctly found that Ms. Figuera's supervisor subjected her to a hostile work environment, because York failed to show either that it exercised reasonable care to prevent and promptly correct any harassing behavior, or that Ms. Figuera failed to take advantage of any preventive or corrective opportunities, Commission should adopt the investigator's finding that there are reasonable grounds to believe Ms. Figuera was subjected to a hostile work environment because of her sexual orientation or gender identity. Very quickly on retaliation, the Commission should adopt a reasonable grounds finding. There are a few errors in the report on this point. First, the factual error. The report states that Ms. Figuera admitted to certain conduct that she did not. Second, the report did not scrutinize the reasons York gave for disciplining and terminating Ms. Figuera. The report acknowledges that reasonable persons could disagree with the justifications that York gave for disciplining Ms. Figuera, but did not go the sort of necessary additional step of finding that this is evidence of pretext, essentially, and evidence of pretext should go to the jury to determine whether the reasons that York gave for the termination were the real reasons that happened, as opposed to illegal retaliation.
That's your time.
So any questions that you may have, I'm happy to answer.
Commissioner questions for Attorney Beard. I see Commissioner Douglas, Commissioner Ashby, Commissioner David, in order of seniority, Commissioner Ashby.
Thank you. I want to focus on the retaliation claim. As I understand the timing, the Human Rights Commission complaint was filed in December of 2020. Is that correct?
The initial complaint, and then it was amended twice in the spring of 2021 when additional retaliatory conduct took place.
Right. But in prior to the disciplines of March 2 and March 10 of 2021, the school was aware, the respondent was aware that the complaint to the Human Rights Commission was contemplated and in fact had been made by the complainant. Is that correct?
That is correct. And as we allege in our filings, the temporal proximity there is also evidence of retaliation.
And I know that you claim, I'm focusing on the March 2 and March 10 incidents because I think that is the claimed basis for termination. You claim that that's pretextual. Did the investigation do any assessment of comparables or a discussion about whether other employees had been disciplined the same way for the same kind of behaviors?
No, and as far as I know, York has not offered examples of comparable employees who were disciplined or terminated for those reasons. And one of our arguments in this case is it's simply not credible that at a time when special education teachers, especially teachers in general, are in such short supply that York would terminate a teacher for the stated reasons, as opposed to for retaliation and pretext for retaliation.
One thing that jumps out is on March 10, the complainant is accused of having not followed a sort of directive to cancel an IEP meeting. My understanding is her response is that the parents wanted that meeting to happen and that the school psychologist had already agreed to stand in. The investigator found that the school psychologist denied that interaction. Is it true the school psychologist denied that the complainant's response to that allegation?
I'm not sure that denied would be the word. I think there was a discussion between Ms. Figuera and the school psychologist. Ms. Figuera, her interpretation was what she said it was, and the school psychologist, I think afterwards said, "Oh, that's not what I meant." But I don't know that it was a denial or there was any sort of mischaracterization necessarily, as much as there may have been a misunderstanding of the matter.
And I don't want to get too weedy here, and I certainly don't want to talk about something that's not part of the investigation. I'm not allowed to, neither are you, but did any harm come of that failure to cancel the IEP meeting? For example, did the IEP meeting in fact happen? If you know.
As far as I know, it was still canceled. It just was not canceled sort of immediately because Ms. Figuera's impression was that it should go forward.
Right, not canceled immediately and probably not canceled by the complainant per the directive.
I would just note that some of the information I'm getting in the message that some of that information was not in the record.
Okay. Fair enough. No, and I definitely don't want to go outside the record. All right, in any event, then the plan is to meet regarding those two incidents. The plan is to meet with the complainant on March 26. On March 25, the complainant asked to leave on FMLA, and then a month later, presumably at the end of that FMLA, the complainant is terminated, not terminated, indicated, got a letter of warning, and then ultimately a week or so later, a couple weeks later, was told that they would not be offering her a contract.
Correct, and told that they would not be offering her a contract sort of immediately after she filed another amended complaint in her MHRC matter.
So I don't want to simplify things beyond what you intend, but is that then a pretty succinct, or is that a satisfactory sort of assessment of the timing of the retaliation claim? And is it your belief that the proximity in time, in fact, does present evidence, at least an even chance of a retaliation claim here?
That's right. Yes, I would say.
All right.
That temporal proximity, I think, is very important.
Thank you. I have no further questions.
Commissioner David?
Did the comments and behaviors that you say created a hostile work environment stop after the complaint and after the warning letter to the supervisor?
A specific focus on Ms. Figuera's sexual orientation, I think, went down.
Well, it went down or stopped?
I don't have specific examples after that, so I think that's fair to say that it stopped. Unfortunately, though, it was sort of replaced with a retaliatory approach to Ms. Figuera as an employee, resulting in a discipline very quickly into the new school year, and then additional disciplines later on, and then her termination. So while the comments specific to her sexual orientation may have stopped, retaliatory treatment increased.
What was the discipline?
So there was a discipline in, I believe, September. It was Ms. Figuera had never been disciplined before in her 20 plus years as a teacher. And well, I don't have the details at my fingertips. I think it was just sort of a professional dispute about something in the workplace. And then the incidents in March were what Commissioner Ashby just focused on.
I guess that we're talking about the same thing with the psychologist that Commissioner Ashby was talking about, but there was a mention of complainant misrepresenting the position of a psychologist, which strikes me as a very serious allegation. Does she admit that she did that?
No, certainly not. As I said, I think Ms. Figuera would strongly deny she misrepresented anything. She spoke with the school psychologist, thought they were on the same page about this meeting going forward. particularly because Ms. Figuera had been told by the parent that it was very important that the meeting go forward. So with Ms. Figuera thought, the school psychologist on her side, she said, let's proceed with the meeting. Afterwards, I don't think that the school psychologist ever said, you misrepresented what I said. I think she said, oh, there was a misunderstanding here. York may have characterized it one way, but certainly Ms. Figuera would strongly deny she misrepresented it.
My last question is the same question that I asked respondents council. Does it make any difference that what we're talking about is not a termination, but a decision not to offer a contract after a probationary period?
No, as respondents council said, it's an adverse employment action either way, and either way it could be, actionable retaliation.
Doesn't your argument cut both ways that the need for special education teachers argues for the fact that they would bend over backwards to try to keep her if they thought she could fit in with the school?
I don't know that I would say that it cuts both ways, because again, I think the reasons given for the discipline certainly don't appear to amount to me to something so irreparable that they would have to get rid of somebody if they needed that badly. It appears much more, to me at least, that it's evidence that a teacher that they really should have kept, they got rid of because they didn't want to deal with someone who had raised these complaints.
And who's the they in that sense? How many people are making the decision to not offer her a contract? It's not the supervisor.
Correct. And I think that's probably outside the record. I don't have sort of internal, but when I say that, I'm referring to the administration, the superintendent, the principal, the assistant superintendent.
But you're saying that all of them together, the assistant superintendent, the administration, are unlawfully discriminating against her by not offering her a continuing contract at that point.
I think specifically unlawfully retaliating against her. And, something we haven't gotten into today, but very much is in the record, in the 2020 to 2021 school year, Ms. Figuera did meet with all the people we just talked about, the assistant superintendent, the superintendent, and the principal, and tried to talk to them about what had happened with her supervisor. Again, she had never been told that any action was taken with her supervisor. And all of those people essentially continued to tell her, we can't talk about that. We're not going to get into that, Ms. Figuera. So I think it is reasonable to surmise that those individuals would be hired of Ms. Figuera's complaints about this.
You're saying that she has a right to know what they're doing with the supervisor? That's personal. They're not telling her what they did to her?
If York is going to argue that it took adequate action to correct the discrimination here, I think they have to do something other than tell Ms. Figuera no policies were violated and we're done talking about this. I do think that's correct.
Yeah, so to brief, both of my questions have been answered. I appreciate that. I just want to sort of nail that. So first of all, Attorney Wade argued that the harassment did not alter the conditions of plaintiff's employment, right? Number 4 in that standard there. And I just want to, your argument, as I understand it, is that the conditions of her employment were altered insofar as she was marginalized. I think the word was used. Like her feelings about being at work were changed. Do I have that right? Or
yes, essentially. So again, legally, that the idea that the conditions of employment were altered is not its own element of that test.
right, it's
Right. It's
Yeah.
part of one phrase, and that is important because otherwise you quickly move into the realm of, well, you're looking at whether an adverse employment action happened, and that's another claim. That's not what we're looking at here. This hostile work environment claim is specifically for a situation where there wasn't a tangible adverse employment action. It was instead severe and pervasive discriminatory treatment. And courts have said that, a discussion of a person feeling humiliated, marginalized in their workplace. I believe it's in the record that Ms. Figuera would feel physically ill at work because of this treatment. Yes, I think that does show that her conditions of employment were altered.
In terms of the respondents' response to this discrimination that happened, I think you said it, they need to do more than just sort of say, the situation's been dealt with or whatever it is they said. But I think the record is also clear that there were no more of these inappropriate comments after they had spoken to the employee. I mean, can we agree on that?
Yes, I think we can agree on that.
Okay, so I guess I'm just wondering, why isn't that adequate now? You know what I mean? If they take action, then the harassment stops. Explain to us why that's not an adequate response.
Well, the employee has still suffered a great deal of harm. So that doesn't sort of all go by the wayside, simply because the employer does something later in time. As it's named for the Supreme Court cases, it's based on the Farragut-Eller doctrine. It requires a two-step thing. One is action by the employer, which again here, I don't think they took adequate action. But two, that the employee failed to take advantage of that, or of any opportunities that were available to the employee to seek corrective action. And again, here, the employer doesn't even argue that happened. So the employer can't escape liability.
Okay, just one more question. The pretext thing. I just want to make sure I understand your position, because we've had a lot of questions, and this is an opportunity to sort of clarify where you're coming from. Because there's evidence in the record that some inappropriate things did happen with your client at work. And obviously the employer can terminate for, bad job performance, right? You're claiming this that the reasons why she was terminated were pretextual. And I was hoping maybe I could get you to distill why you think that is in the space of like a minute or so. Not clear from your other.
Sure. Well, I think the key, and as the investigator pointed out, there's a lot of room to disagree about whether the reasons that York gave for disciplining Ms. Figuera and ultimately terminating her justified that action. And I think if you're in a place where you're questioning whether that's a reasonable basis to justify a termination, that is sort of the pretext world where a question of is this an adequate reason to terminate someone? That question is a credibility question that would go to a jury. It's not something that should be thrown out up front. And here that is effectively what we're doing by saying there's no reasonable grounds. That would be something that wouldn't go to a jury, right? Where you have other potential evidence of retaliation, and as Commissioner Ashby focused on, there's a lot of temporal proximity evidence here. That's a lot more reason to really get into an employer stated reasons. And if there are doubts about whether those reasons are valid, that's evidence of pretext, and that's something that should go to a jury.
Thank you.
So
That's helpful.
Any additional commissioner questions for Attorney Beard? Seeing none, thank you, Attorney Beard. Attorney Wade, you have about 4.5 minutes left.
All right, thank you. So with respect to the sexual orientation retaliation, or sexual orientation discrimination claims, two pieces, obviously. With respect to the severity and pervasiveness, as well as the creation of an abusive work environment, Attorney Beard has listed a series of impacts that this could have had on complainant, but is not pointed to anywhere in the record where complainant actually alleged that these things did occur to her. It is not just severe and pervasive, it's severe and pervasive enough to alter the terms and conditions of her employment, which they have not demonstrated. More importantly, they continue to allege that the school did nothing to correct, next to nothing to correct the harassment once they learned of it. This is objectively wrong, and throughout the record, it's clear that as soon as they were aware that the unprofessional comments were being made, they issued discipline in less than 2 weeks. No comments were ever made afterwards regarding sexual orientation. That the complainant does not like the outcome is not evidence of discrimination. So we would again urge the commission to find no reasonable grounds on the sexual orientation discrimination claim. With respect to retaliation, I think what's really important about these, especially the March 2nd and March 10 incidents, are that they're very significant for a case manager. Again, a case manager's role is to work with teachers, to work with colleagues, to work with other special education professionals in order to put together programming and just then give that programming that is best for students who have identified special needs. In one incident, the complainant completely refused to work with a colleague who had a professional disagreement with her about an assignment that a student was given. She avoided the teacher repeatedly to the point that the teacher, who has no knowledge of any of this Human Rights Commission case, had to go to the administration to ask for help in communicating about a basic assignment with this case manager. That was non-collegial. She then proceeded to follow up by saying the teacher's actions were disgusting and insulting and refusing to take responsibility for her own unprofessional behavior. That is not the collegial behavior we expect of a case manager, especially during a probationary period. The second incident related to the cancellation of a meeting. She is the case manager. The very fact that she was prepared to not be present for a student's IEP manager as the case manager with the most amount of knowledge regarding the student's programming didn't make sense to the school department. After being repeatedly told not to cancel it or to go ahead and cancel it, she did not, and then misrepresented the school psychologist with respect to her opinion on whether or not the meeting should go forward. These were extremely significant, suggested she had trouble working with others, failed to take responsibility for her actions, and especially during the probationary period, told York that they could not continue this person's employment. The last piece about the temporal proximity that I wanted to say is that part of this was all sort of delayed because she did take leave. The York School Department asked to meet with her on Friday, March 26th. On Thursday, March 25th, she asked for family medical leave, which resulted in the York School Department asking her to answer in writing some of the concerns related to these two incidents. That took a few weeks. Once they received her response, they put together their response, issued a discipline letter, and then about a week after that, went ahead and notified her of their decision not to nominate her for continued employment. So the temporal proximity related to the revised complaint all sort of has to do with the fact that she was on leave at the time, but the school department was essentially doing their best to continue to address these issues and make sure they had a good understanding of what happened before they took action that was going to affect this person's employment. So again, we would urge that the commission adopt a no reasonable grounds findings with respect to the disability discrimination and retaliation claims.
Thank you.
Yes.
Any commissioner questions for Attorney Wade? Seeing none. Thank you, Grace.
Okay. Thank
you. So next we will hear from the investigator, Alex.
Morning, commissioners, Amy. My name is Alex Brindley. I was the investigator assigned to this case. I'm not really sure I have anything further to add. Yeah, I think the attorneys really were able to adequately explain really the key components of this case. I guess if I were to surmise my recommendations going in order from how they're presented. So if we talk about the hostile work environment claim, there was this issue of prongs 4 and 6. 4 meaning harassment was sufficiently severe or pervasive so as to alter the conditions of plaintiff's employment and create an abusive work environment. For me, based on everything that was alleged, and it's all written in the complaint. The complainant was subjected to multiple comments based on her sexual orientation, asked whether or not she could sense other gay people, whether or not her and her wife had roles in the house. And that to me is, I mean, there were multiple incidents, so that itself is pervasive. We only need one or the other, but it was also severe because Ms. Figuera indicated that she felt marginalized and harassed, and yeah, XYZ. And then for the sixth prong, that some basis for employer liability had been established, there was some disagreement with that. So I want to point to the paragraph 6 of my hostile work environment claim regarding employer liability. It states, when no tangible adverse employment action results, the employer may raise an affirmative defense by proving by a preponderance of the evidence both that it exercised reasonable care to prevent and correct promptly any harassing behavior, and that the complainant unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to avoid harm otherwise. Now, the reason that I decided that there was employer liability in this case is because the complainant did in fact take advantage of the opportunities provided to her. She told her supervisor that these comments and her conduct was inappropriate and she felt harassed by it. And then she further on went to the York School District to report that further. And like I believe Attorney Beard stated, simply because the comments about her sexual orientation ended after the investigation and the subsequent discipline happened doesn't mean that the harm didn't still occur. And if we move forward to the retaliation claim, I think I have less to state about this, but basically I was focused mostly on the incidents the disciplinary incidents that complainant engaged in March 2nd and 10. There was she disagreed that she didn't, let me start over. So on March 2nd, the March 2nd incident, the complainant disagreed that she refused to speak to the teacher here. However, based on what I read, it did seem like Ms. Figuera did not speak to the teachers, so that the teacher had to go speak to supervisor about XYZ. So there was some sort of tenuous incident there. But yeah, and then there's the incident of March 10, wherein the respondent stated that it was a misrepresentation. I'm not sure I would go that far. But she certainly did state that the school's psychiatrist indicated that she could sit in on the IEP meeting for her when that was not the case. So it sounds like I did have something to say, but I am open to questions.
Alex, Commissioner Ashby.
Alex, this is a good report, by the way, and I don't mean to suggest I'm being critical. I honestly don't know the answer to the question I'm about to ask. And in fact, I'm inviting Barbara, our counsel, to jump in if anyone thinks it's helpful. Your paragraph 6 is where I was focusing as well, on page 6. And I will take it at face value that the respondent did in fact exercise reasonable care to prevent and correct the harassing behavior. I'm troubled though that the assessment then goes to your prong 6, that in order for the complainant to prevail, the respondent has to fail to prove that the complainant unreasonably failed to take advantage of preventative or corrective opportunities. Don't you think that the standard is that the complainant thereafter has to unreasonably fail to take advantage of any preventative or corrective opportunities? And the reason I ask this is traditionally a person makes a complaint about a coworker or even a supervisor. The the powers that be are notified of that, they then discipline or whatever, which occurred in this case. And if they do that and nothing else happens thereafter, isn't the respondent or the employer, aren't they able to escape liability at that point? It seems to me that the standard suggests that the harm still has to occur after the employer first learns of the problem and then takes prompt action. And if we can see that the employer took prompt action in this case and appropriate action in this case, it seems like it can't do any more. There's no way. And that last prong, it seems like that last prong has to only be result in employer liability if in fact there's further harm thereafter, like the employee keeps on doing the bad behavior, the supervisor keeps on doing the bad behavior. Am I off the mark with that? I mean, that's my concern about your assessment on that claim.
Barbara?
Come on, Alex.
Oh.
Sorry, I am now stuck in my earring. Just a sec. Okay. So, and I understand your concern as well, Jeff. But the places where we have applied this sort of situation is where an employee does not report, or an employee knows that there's a policy, knows that there is an EEO coordinator, for example, and tells their friend who happens to be a little higher up on the chain, who doesn't pass it on, or cases where the employee does not do what this employee did, which was confront her supervisor, and when her supervisor continued to make these comments, carried it up the chain of command. This employee did everything that was made available to her. The other thing is that whatever action the employer took, in this case, it didn't provide any additional opportunities to complainant to prevent harm. And the leave came after the fact, the leave related to stress because of the environment. So I don't think it's really fair to say that because there's no evidence that this one supervisor didn't make any comment, any further comments, that poof, everything's okay. I realize that was not my most articulate explanation, but
no, that was helpful. I think it perhaps, from my perspective, I think it's perhaps important to know that it is a supervisor making the comments, not a fellow, just a coworker of the same level. And I think that the comments continued after the complaint to the supervisor was made, although the complainant would have no reasonable expectation that the supervisor would discipline herself. I think that may be a distinction, but otherwise it seems like an employer can't win, right? If an employer hears of a problem and they promptly fix the problem and the problem stops, there isn't anything for the complainant to do thereafter, either to take advantage of or to not take advantage of, right? It's the problem's over. That's almost this case. I think I see your distinction, and maybe future cases this will come up again, but interestingly, and I do think I'm focusing, I'm not sure what motions are going to be made and how I'm going to vote, but I am interested in the subsequent, the stress claim. It does seem to me to be a function of a response to actions by the employer that look an awful lot like a discriminatory response to this complainant making complaints. And I may think, and Alex, I'm interested in your opinion, I may think that the shakier finding of yours is that there's not evidence of retaliation. That may.
I'm sorry. I wanted to raise one thing on that issue before, because you were talking about the timing of the notice of failure to offer a continuing contract. And I just wanted to point out that that timing is dictated by statute.
Right.
The education statutes provide that if a probationary teacher is not, or is in fact, if they're not going to be nominated, they need to be notified before May 15th of that year.
So as far as the timing of that notice, and I'm not talking about the other things that the March incidents and whether or not that's sufficient, but just that issue of temporal timing, that part of it is dictated by statute.
Right. Okay, well, I don't think I have more to ask. Thanks.
Other questions from commissioners for the investigator? Not seeing any at the moment. Thank you, Alex.
Thank you.
So commissioners, we have heard from the parties and the investigator. There are two proposed findings here. It might make sense to take them separately. And actually, the first proposed finding lumps two claims together, disability and retaliation. So if you want to split those out, we may need more than two. Commissioner O'Brien.
I would move, first of all, no reasonable grounds to believe that York School Department discriminated against Michelle, I apologize, Figueroa on the basis of disability or retaliated against her for engaging in MHRA and or WPA protected activity, and these claims should be dismissed.
Is there a second?
I'll second.
Is there any discussion?
Not sure what the appropriate procedure is at this point, but I do feel that, you know, consistent with your suggestion, we should perhaps split these two out and vote on them separately, the disability and the retaliation.
I was going to suggest the same because I'm inclined, I'll tell you now, show my hand. I'm inclined to believe that there's an even chance of a claim of retaliation here, but I would support a no reasonable grounds finding as to discrimination.
You mean disability discrimination?
I'm sorry, disability.
So you can either vote on the pending motion, or you can ask Commissioner O'Brien to withdraw her motion. However you all want to proceed is fine.
I'll
Commissioner-
withdraw my motion.
Commissioner Walker, do
I'll
you
withdraw the
have a
second.
second? Okay.
I'll move that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability. As a result, that claim should be dismissed in accordance with the act.
Second.
Been moved and seconded to find no reasonable grounds on the disability discrimination claim. Is there any discussion among commissioners? I do not see any. So if you agree with the no reasonable grounds finding on disability, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
So that takes care of the disability discrimination. Is there a motion on the retaliation?
I'll move that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of engaging in MHRA and or WPA protected activity. And as a result, the claim should be referred to conciliation.
Second.
So it's been moved and seconded to find reasonable grounds on retaliation. Is there any discussion among commissioners? Seeing none. If you agree with the reasonable grounds finding on retaliation, we'll vote yes. Commissioner Ashby,
Yes.
Commissioner David,
No.
Commissioner O'Brien,
No.
Commissioner Douglas,
Yes.
Commissioner Walker.
No.
So the motion fails by a vote of 2-3. So without a finding of reasonable grounds, the default is a no reasonable grounds finding?
Not anymore. Oh, well, it is
Not
because
tied.
that's what
It's not
happened.
tied, right?
No, well,
That's only in the event of a tie. Right?
sure. It would be easier.
It would be cleaner if we had no reasonable grounds motion on the same claim. If someone were so inclined to make that motion.
Well, I'll move that we find that there's no reasonable grounds to believe there was retaliation for engaging in WPA or MHRA protected activity, and the claim should be dismissed.
Is there a second?
I'll second that.
Is there any the motion is to find no reasonable grounds on retaliation. Is there any discussion among commissioners? Seeing none, the motions for no reasonable grounds on retaliation. If you agree with that, you will vote yes. Commissioner Ashby,
No.
Commissioner Walker, I'm sorry, Commissioner David,
Yes.
Commissioner O'Brien,
yes,
Commissioner Douglas,
No.
Commissioner Walker.
Yes,
So that motion passes.
And finally, I'll move that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of sexual orientation or gender identity, and conciliation of the claim should be attempted in accordance with the act.
Is there a second?
Second.
So it's been moved and seconded to find reasonable grounds on the sexual orientation or gender identity claim. Is there any discussion among commissioners? None. If you agree with the reasonable grounds motion, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
No.
Commissioner O'Brien,
no,
Commissioner Douglas,
Yes.
Commissioner Walker.
yes,
So the motion passes. And so we have one reasonable grounds finding and two no reasonable grounds finding. The commission will send both parties and council a letter confirming the findings, and we thank you for participating today.
Yes, thank you very much. The next case we have today is E 21-0270 and B. Bryce Young versus Judith Shaw, and this is a no reasonable grounds case, if I'm remembering correctly. And as a result, we will hear or should hear from the complainant.
I do not believe that the complainant is present, which is what he had stated in his submission, that he did not intend to appear, that we needed to offer him a process in case he did appear. So I do not see him either on Zoom or in person. So commissioners, traditionally, when the objecting party does not appear, the commission votes to adopt the recommended decision in the investigator's report without hearing from the non-objecting party who is present. In which case, if we choose to do that, we would be looking for a motion to adopt the proposed findings. Commissioner David?
I think we can take them together. I move that we find there's no reasonable grounds to believe that respondents discriminated on the basis of sex, and no reasonable grounds to believe that there was retaliation in violation of WPA and WHRA protected activity. And the complaint should be dismissed.
second,
Thank you. Any discussion among commissioners? Seeing none. The motion is to find no reasonable grounds on both claims presented. If you're in agreement, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
I apologize, yes,
Commissioner Walker,
yes,
Commissioner Douglas.
Yes.
So the findings are no reasonable ground. And we'll send parties and council a letter confirming that. Thank you to respondent and council for being here. And that is the end of our hearing agenda. So, by the way, best hearing agenda ever.
What happened? I mean,
It's just the way it works out, Ed.
We were convincing in this round, apparently.
Yeah. So at this time, we would be looking for a motion to go into executive session, citing. Okay,
Pursuant to 1 MRS section 405-6E, I move we do go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
second,
second.
so it's been moved and seconded to go into executive session. If you're in agreement, you will vote yes. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Okay, at this time,
We need you to go.
okay, perfect. So at this time, we'll move both physically and electronically into executive session. I believe we what did we do last time? I don't remember.
Well,
Pause because I can't go into the breakout room. We have to come out before we can leave. Right. Yes. Because we were streaming online, recording.
still. Yes. Can I keep them all here to be training? Hey, not if we're not conducting commission business.
That's not a meeting.
It'll be okay. Yeah, well, we can adjourn the meeting. Sorry.
Okay. So I think we don't pause. We don't pause the recording.
Then you're gonna be broadcasting this as the recording.
Okay,
On YouTube.
okay, so we're pausing. You do your thing. I'm gonna move the commissioners into executive session.
And you have to invite me if you want to use the TV.
I shall, if I can figure out how.
I mean, you just eavesdrop.
Hold on, I use device.
If you come in, Chelsea, what happens on YouTube?
I was just gonna make sure once I get the invite, she has the YouTube page up. We can double check before I walk away.
Okay. Right. Yeah. Trying to figure out how to invite you, but I can't figure out how to invite you. Maybe you could just go in there. I don't invite you. You can just go into the room. Right, I open the room and both you and I are hosts. We can both just join that. I'm gonna try that.
That worked.
E20.
You're unmuted, I'm sorry.
Thank you.
For a second.
At this time, we'd be looking for a motion regarding litigation or not of E20-0475, the Gorman case.
Move we not litigate that case.
Is there a second?
Second.
So it's moved to not litigate E20-0475. If you're in agreement, you will vote yes. Commissioner Ashby? Wait,
Yes.
there's Julie.
You're unmuted.
Okay.
I can.
At this time, we'd be looking for.
And actually.
You got to pin both. Yeah. So thank you, Jeff. I got you. I got your vote not to litigate E20-0475. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes.
Thank you. And is there a motion regarding a conciliation agreement in E20-0295?
Move that we approve the conciliation agreement in E20-025.
Second.
It's been moved and seconded to approve the conciliation agreement in Ally versus C&G. If you vote yes, you're in agreement. You should vote yes if you're in agreement. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Excellent. And with that, I believe we can adjourn. We don't need a motion to adjourn the meeting. And we're going to take, that's the end of the commission. That's the end. Thank you.
You said 5 minutes?
Yes, 5 minutes.
Great, thank you.
Stop recording. Can you turn off the YouTube? Chelsea, you have that.
Yes.
Okay.
If you want to stay on, or he said 5 minutes.
Oh, that's right. I forgot we're using your computer.
Oh,
But I'm a co-host. First of all, just turn off YouTube.
yes, but you want me to keep it on?
Still showing YouTube on mine.
Yeah, I can still see it.
I think it's just the delay. I don't have it at the top anymore. Do you?
It's still showing up. Yep.
On your Zoom?
Yes. You're on the YouTube and it's still showing. Yeah, so it's still, it's got it on and it's still on there.
I think it's just the delay. I don't have it at the anymore. Do you?
It's still showing up.
On your Zoom?